Hello and welcome to my Management 200 funnel project. I'm going to be going over employee discrimination and specifically including the LGBT community. To start off, I need to talk about Title VII. Title VII is a section of the Civil Rights Act of 1964 and gives employees certain protections against discrimination. It applies to employees who work for companies with 15 or more people. Title VII specifically prohibits discrimination against deemed protected classes like race, color, national origin, gender, religion, or sex. This term was brought in only in 2020 to expand gender sex protected class to include sexual orientation and transgender status. In the past, those who have been accused of violating Title VII have fought this broadening of protected classes, or they argue these employee characteristics are a bona fide occupational quality. This defense is usually used by religious organizations, usually with regards to religion protected class. Good example of this is like usually in churches or religious organizations. Basically hiring and firing people based on their religious beliefs. Out of the three cases I'll present, there are three distinct arguments being made in order to justify the termination of an individual from their position to avoid any claims of violating Title VII. The defense in case one just brings up the question of firing someone for their sexual orientation counts as discrimination based on sex. Case two acts as the Supreme Court of Title VII prohibits the discrimination against transgender people based on their status as transgender. And case three asks that the Boy Scouts of America can consider being a heterosexual male a bona fide occupational qualification. Case one, Gary Bostock was fired after his employer found out he participates in a softball league for LGBT members. He sued his previous employer for violating Title VII. It was rejected by the 11th Circuit, and they decided that Title VII does not protect someone who is gay. This case was then moved to the Supreme Court, and they made the opposite decision. This decision basically argued that, to quote, this is because in firing a person for being gay or transgender, the employer has fired that person for traits it would not have questioned in members of a different sex, which is exactly what Title VII prohibits. Bostock, the former employer, tried to argue that being homosexual is not the intended meaning of gender, and Title VII was written in 1964. This decision was a major relief for those who worried about their protections for who they are. In case two, Amy Stevens worked for R.G. and G.R. Harris Funeral Home for 6 years from 2006 to 2013. After informing her employer of her intention to transition gender, she was soon terminated from her position. After her former employer could not give a reason for her termination, she filed with the Equal Employment Opportunity Commission. The EEOC and Harris Funeral were not able to mediate this dispute, and the case was taken to the U.S. East Michigan District Court. The district court decided that Title VII did not protect transgender individuals. The 6th District Court allowed Stevens to intervene on appeal and reverse the decision of the district court. In case three, in 1992, James Dale filed a suit against the Boy Scouts of America after the Scoutmaster status was revoked after the organization found out that he was a homosexual. Dale was filed in a suit against the organization for discriminating against him for his sexual orientation. While this specific case does not involve a direct violation of Title VII, Dale believed it violated public accommodation laws specific to New Jersey. While the Boy Scouts of America Association cannot prove that sexuality was not a bona fide occupational qualification, the New Jersey Supreme Court did say the organization had the right to exclude Dale through the right to the First Amendment, arguing that, quote, according to the Boy Scouts of America, homosexual conduct was inconsistent with the values they wanted to instill in young people. Why this all matters. Despite the previous precedent guaranteeing protections, these cases still matter due to the current work climate we live in. Here we see the percentage of people who feel that LGBTQ people are treated worse in the workplace in a study by the Williams Institute. While discrimination by employers is now covered under Article 7 in these new transgender and sexuality roles, it still happens in the workplace. I believe solutions need to be implemented to prevent loopholes or other legal ways it can still occur. This could include updating Title VII to improve the clarification of discrimination based on gender, and other considerations expanding Title VII to employers with less than 15 people, and seeing if organizations like the Boy Scouts of America would have to follow similar laws, basically. Here are my sources. Thank you for watching.